Could you take us back to the Nixon administration when they conducted their operation against your psychiatrist's office?
Yes, following this trial, which you've helped me do so much, Kevin, I appreciate it. You're doing a great job there. And I know what it's like getting up so early in the morning to do it, too. It's not easy for me. But unfortunately, this whole thing, as I follow it with you and Joe Loria, is forcing me to relive my own trial, which is not something I ever wanted to do. I've written 2 memoirs since then, and I always said that I would never include the trial in a memoir because I just didn't want to relive it again. And I identify very much with Julian, who has to listen to this stuff and have even less opportunity to talk to his lawyers and advise them on what to ask or what the aspects of this are that they're not as likely to know as well as he does. So I lived through all that, and it was a very, very stressful experience. Now, in the case, what we learned, of course, late in my trial was that the White House team, the Plumbers that reported to the White House, had conducted a burglary into my former psychoanalyst office in hopes of getting information primarily in order to blackmail me into silence about what I knew about what Nixon was threatening at that time, which included nuclear threats against North Vietnam. And they feared that I had documents that would prove what I was saying about these threats that were being made. Unfortunately, I didn't. I could have had people who did know of them leaked them or presented them as they wish they had. At least I can know one of them who says, Dan, we should have thrown open the safes and screamed bloody murder, because that's exactly what it was. And he very much regretted that he had not taken out documents that would have indicated that. But they feared that I did have that information. So they were very concerned to know exactly what I had and what I might do in the way of releasing other information. Another thing, of course, a secondary thing, which people thought was the primary thing, was to defame me. Actually, I was facing 12 felony counts already, federal counts in trial. So they'd done a certain amount to defame me already by those charges. But they wanted to be able to indicate, for instance, that I was unbalanced, just as as they wanted to do against Julian or Ed Snowden or Chelsea Manning, and to denigrate whatever else they might come out with or what they already had come out with and what I might say. So there's this, on the one hand, the effort to coerce me into not saying more, and the other hand, and to know, by the way, if it possible, this wasn't so much from the raid on the burglary on my psychoanalyst office, as they called on a CIA psychiatrist who had patients, by the way, to whom including anti-war people, to whom he had never revealed that he also was a consultant, a regular consultant of the CIA. Some of them were a little concerned to learn that when it came out as a result of my trial. But they wanted him to, on the one hand, to be able to get things that they could perhaps use to defame me, but also to know how to manipulate me. And again, as I say, they were very interested. You know, something comes back to me as I say here. It couldn't be more relevant in a way, but they called in somebody who had done psychological profiles of foreign leaders like Sukarno and Castro and various Soviet leaders, precisely in order to know how to manipulate them, or how to deal with them in various ways. And I just realized that one of the things I was told by 2 reporters who looked into the Plumbers and what they'd been up to, that they wanted several things out of me if they could threaten me sufficiently. And there were 3 things in particular. One, to cause me to flee the country. That's pretty interesting. In those days, that would have meant the Soviet Union, which we had the Cold War adversarial relationship with, which would have identified me as a traitor or a non-patriot of some kind. So they wanted me to flee the country if I could. Second, to cause me to not get on the stand in my defense. And if I hadn't done that, I think my chances of any kind of acquittal were very, very small. And for that reason, by the way, they were interested in anything they could bring to bear on my children or my wife. And as one of them said, in his trial, with which Nixon was always comparing this, his great moment of triumph when he brought down this East Coast intellectual, and he identified me with his. I was even better. I was Jewish East Coast intellectual, perfect foil for him, he figured. And his son was the only person who could testify supporting Hiss's claim that he had only a cursory acquaintanceship with Whittaker Chambers. And they wanted to keep the son off the stand. And so they had evidence that the son was gay, which in those days would have affected, ruined his career pretty much. Nowadays, it wouldn't be enough probably, or even do the job. But then, and Hiss didn't want his actually stepson, to be afflicted with this, so he wouldn't let the son get on the stand. And that was the kind of thing they wanted to get. They were looking at my children and my wife in hopes of getting anything that would influence me. And a third point, which these Cuban emigres who were working for Hunt and Liddy, the plumbers, in going into the office, was to cause me to commit suicide.
Yeah.
Very interesting, because that's, of course, come up as such a factor here now. Now, it's being raised, as I understand it, by the defense against extradition in a case where he clearly should not be extradited anyway as a political matter, and not be extradited to face an unjust trial in the U.S. and not be extradited as a journalist. There are all these reasons why he shouldn't be extradited at all. But they are focusing on the question that he's a suicide risk if he's called this. Well, that was of interest in my case. It wasn't going to happen. But if they could find stuff that would make me commit suicide, that was okay with them. And I would say, following this case, I find it hard to believe that any people at the higher level of the prosecution side, meaning the Oval Office, the president, and the attorney general coming down the chain on this, would be sad if Julian Assange committed suicide,
Right.
or if he died in prison as a result of what's going on, of COVID, for example. In other words, these are people, I think, who are essentially heartless about their adversaries.
So, this is my first opportunity to talk to you and hear from you about your testimony, and so I'm curious, based on the questions that the prosecutor had for you when you testified in the extradition trial, what are your thoughts on how the prosecutor, or the prosecution maybe more generally, is handling this trial against Assange? Was there anything that stuck out to you from those questions that were put to you?
Well, Kevin, I think it was you and not others who made the judgment that he was handling me more nicely than he had other people. I wasn't, not having watched this the way you have, I wasn't in a position to tell that, but that he was somehow more almost deferential in the early part of his questioning. He got testy later. I was just, as I read that comment by you, I was thinking that possibly a reason that I seemed to be calm and not too rattled by his aggressiveness was that I had trouble hearing him. This maybe deaf people are harder to get under their skin because you don't hear the insults or the hostility in the question. But I did have trouble hearing, or for that matter, the defense lawyer. So, but I didn't have the feeling that I was being unduly pressed. And it's obvious from your reporting that that's in many other cases, he's been much tougher. I think a factor there, by the way, was that, as I understand it, I was told at the last minute that I was not being put forward as an expert witness, although I am expert in certain aspects of this case, the secrecy system in particular, but and the kinds of things that Julian was reporting. But I was being put forward as a fact witness, whatever that means, and that may have affected. He didn't go after my credentials particularly, as far as I'm aware, which has been his main thrust, I guess, with other witnesses. Is that what
Yeah.
you've been seeing? Is that what you would say?
Yeah, no, and for a lot of the witnesses, responding to what you just said here, a lot of the witnesses have gotten the question, are you trying to help the court or are you advocating a cause in order to make them seem biased to the judge, which has been striking to me because having followed Chelsea Manning's trial and other trials in the United States, I've never seen a prosecutor so blatantly attack witnesses who are being put on the stand. But apparently in the UK, there's some kind of a rule that says any witnesses, whether they're defense or prosecution, have to be balanced and consider all of the evidence from the defense and the prosecution in whatever they submit to the court.
Isn't that, wouldn't that be for expert witnesses or not? Because they are all presenting themselves virtually in one sense or another as experts, as I have in other trials. I've been an expert witness several times in the U.S., but I thought maybe that's just for experts. In my case, it would be absurd to say that I'm impartial here. Are you kidding? Do I have a cause? Yes. Freedom of speech and freedom of information is one of my causes.
Yes.
And not the only one. Anti-nuclear cause, anti-aggression cause, for example, which very much comes into this case. I perceived Julian and Chelsea Manning in particular, and Julian in reporting this, as being at one with Chelsea in a desire to get out information that would shorten an aggressive war in Iraq. And I would certainly, I would never suggest that I was impartial on that moment, on pros and cons of an aggressive war or of torture, for example.
Now, you said that the prosecutors have been misrepresenting the indictment, and you've also followed the other people who have called attention to how the prosecution is misrepresenting their indictment. I've picked up on the misrepresentation of the indictment. Why do you think this is more of an opinion kind of a question, but they seem to want to hide the fact that they're criminalizing the publication of information by a journalist. Do you think this misrepresentation is to try and squeak this extradition through a UK court?
Well, I've been very puzzled by it, reading the accounts, and I have to keep saying, I read your accounts, I read Joe Laurier's accounts, Craig Murray. Been very puzzled at the repetition of this false assertion that he is being charged only with releasing material which led to, which included unredacted names of informants. He said that to me, and I pointed out to him that, as I had just read, I think the charges are 15, 16, and 17. I've forgotten the numbers, but that he had 18 charges here altogether, and a number of them clearly did cover straightforward reporting, which did not involve names or unredacted names. So what he's saying is so clearly false about his own indictment that I don't understand how he gets away with this, keeping repeating it. Shouldn't, I don't know, the judge or the defense attorney make a strong motion that this misrepresentation to the witness is wrong? I don't see how he gets away with that one, actually. Am I wrong in being puzzled by that?
No, I think it's fair to be puzzled because it seems to be undercutting their case. The fact that they want to only make it about informants and publishing the name of informants it actually suggests that they're not charging it correctly, because we do have an Intelligence Identities Protection Act. So I don't know what,
Well,
I think,
it would not cover the people they're talking about here.
right. Well, that's true. That's true.
No,
Um,
they're talking. It would cover, as I said in my testimony, which is I don't think I've ever had occasion to talk about it before. Since he was asking the question, had I redacted anything? I said
right.
I chose not to redact the name of somebody who would have been covered by the Intelligence Identities Act had it existed at that time. And it would have, I expected it to lead to a lot of challenge from me at the time. It was the name of Lucien Conin, Lou Conin. It was a clear clandestine agent of the USA. He was a colleague of mine, actually, and a friend of mine, to the extent that a covert clandestine agent of the CIA can be a friend. And it's not, I won't go further than that. But he was a friend by my standards. And nevertheless, I knew that he'd been identified elsewhere, that it would not endanger him. I would have, had I thought it would endanger him, I would not have included it. But he had been identified by Marguerite Higgins, among others, in a book well known in Vietnam, that he had been involved in this, in the process and planning of the assassination of Ngo Dinh Diem. So he was known as that. And the question was, though, should I appear? But as I said, you probably know that I chose not to redact that name because I wanted to say these are totally unedited documents by me. I have not removed from them the real justification for our killing in Vietnam, because there was no justification and it wasn't in there anyway. And I wanted to show a negative. You can't find a good reason for our being there, for our killing people there, exactly as in Iraq. There is no justification for our being there in Iraq to kill Iraqis, to kill any more Iraqis, as in Vietnam. And certainly for the continued war for the last 19 years in Afghanistan, I would say essentially the same thing, although they would put up a mock reason for our being there. In Iraq, no. So, and other places. So I left it in and didn't redact. But the idea that he's only being charged with that, which they keep saying, is a flat lie. And how a prosecutor can get away with lying about the charges in the indictment, it's as if, well, I don't know, I could make an example, analogy in my case, but they didn't do that actually in my case.
So I want to read to you, and maybe you know that this popped up during the trial, but I was disturbed by this exchange that happened. It does seem like the prosecution has made this shift, that they've moved away from denying that Julian Assange is a journalist to saying that there's nothing in the law that should stop them from bringing this case against Julian Assange. So I just want to read these quotes for people and then get your view on the way they are approaching these Espionage Act charges now. So Claire Dobbin is the prosecutor who questioned Kerry Shankman, who worked as an associate of Michael Ratner before he tragically died in 2016. Claire Dobbin asked the question, is there a blanket law that precludes the prosecution of a publisher under the Espionage Act for the publication of leaked national defense information? And Kerry responded, my position is that the Espionage Act is so broadly worded as to allow for the prosecution of the mainstream press. And for those who don't know, Kerry Shankman was asked to give testimony because he's written a book about the history of the Espionage Act. So the prosecutor, Claire Dobbin, replied, well, we have common ground then that the state of the law is such that publishers can be prosecuted under the Espionage Act for the publication of national defense information. In other words, I'm glad you agree that this would be bad, because that's exactly why we're going to go forward and bring this prosecution, because in their view, there's nothing that can stop the US government from bringing this case. What do you think, Dan?
Okay, I haven't read Shankman's book, which I will now that it's been.
Oh, by the way, it hasn't been released yet. It's forthcoming, and so that's why nobody has read it.
Well, I will read it because I've been very concerned and followed all the legal reviews and articles on the Espionage Act for the last almost 50 years, 49 years. And the reason for that is that I was the first American to be charged under the Espionage Act for releasing information to the American public, for leaking, for unauthorized disclosure. So I've followed that with great interest. I'm an informed layman on 18 U.S.C. 793 paragraphs D and E. And say that's the only statute I can roll off like that, because I was the first person tried under it. And all of the others now, on leakers, whistleblowers, under 3, including me, before Obama, and then 9 under Obama, and more than that indicted under Trump already. So I am familiar with that. Now, the first answer to Dobbin's question, Chairman, is yes. The plain wording of that act does easily apply to a publisher or a journalist, and just as easily to a reader of the New York Times who's reading an article that says this is based on a classified document available to the New York Times, and they then quote it, let's say, or paraphrase it. According to the plain wording of that act, that reader, generally not being authorized to receive this classified information, if he or she holds it or retains it, or even worse, distributes it by telling their spouse, look at this article, they come under this. Now, that would seem pretty broad. The doctrine, as I learned it, of overbreadth of an act relating to speech crime of some sort here, which could be libel, it could be espionage, giving information secretly to a foreign power during war, especially. The notion, after all, the plain wording of the First Amendment is Congress shall pass no act abridging freedom of speech. Well, there are some people who are described as absolutists who follow that wording and say no act. That was Justices Black and Douglas were famous for that. They were involved in the Pentagon Papers case. But others say, no, it isn't. It doesn't really mean no act. But you have to be very narrow and careful if you do try to abridge any kind of speech act in order to maintain the free speech, the free press that is the very foundation of a republic or of a democratic self-governing nation. And so you can restrict in some ways, as they said, in a restricted way with libel, much more restricted than in Britain, for example. For instance, I can't effectively bring a libel suit no matter what's held about me. I'm regarded as a public figure, and I would have to show deliberate malice, deliberate lying to malign me of untruth. Very hard to establish. And the person can always say, well, this is what I believed, or I read it somewhere, or something like that. So it's a narrow libel. And although I've been libeled a lot and pained by it often as a human, I also support the idea of very narrow libel laws so that you can't intimidate other people with these, which is, of course, Donald Trump's specialty of bringing libel suits that he can't win, just to intimidate and to keep people from seeing critical things of him. Okay, so the idea here then is that if you're going to violate the plain wording of the First Amendment by enacting something that puts a restriction on speech or on reading or on press or on thought or anything like that, it has to be narrow and not vague, and focused on something that Congress deliberately intended to do. Now, in the case of the Espionage Act, it's clear from the legislative history at the time it was debated in 1917, right after we got into World War I, when Woodrow Wilson called for a much even broader act that included censorship, and that was ruled out. And they said, we don't want a censorship law, and we don't want a British Official Secrets Act. Mm-hmm. We want something much narrower than that. British Official Secrets Act then and now would not pass constitutional muster. It's too great a violation of the First Amendment, which Britain doesn't have. So, I mean, that was a major aspect of our revolution, our War of Independence, was to make it much harder to charge sedition, which William Barr is talking about right now, and treason, much narrower, because all of the founders of our country were easily chargeable, were charged, in fact, with treason to George III. And they wanted to make it narrower, although in their case, not unfairly charged, they were levying war against Britain and not really saying mean things about the king. So they said, we don't want an Official Secrets Act. And yet, in paragraph D, for authorized people who had authorized access to this, like me, and all of the other people I think accused of whistleblowing were so far, there's a couple questionable cases, but they were in particular charged with paragraph D for authorized access, which of course Julian Assange did not have. Chelsea Manning did have authorized access to this stuff, like me. So one question is, did the act mean to make that criminal for someone who had authorized access to put it out in violation of their promise not to put out any, as a regulation, not to put out any classified material of protected? No question we were violating the regulation. The question was, were we violating a criminal law? Was the classification system, did it have the status not just of an executive, regulation, which it is, but of a criminal law? And Congress has never passed a law giving legislative basis for that. So can the Espionage Act be used for that? Well, I was the first experiment to see whether it did. And my case was dropped because of governmental misconduct at the end, criminal misconduct against me. And these other cases have been held. The Supreme Court has never addressed the fact the constitutional aspects of the Espionage Act used against whistleblowers, used against people who want to reveal wrongdoing or criminal or deception or terribly dangerous behavior by the government for the public interest. The Supreme Court has never judged whether even someone like me, who had been subject to government regulations, could have certainly been fired, denied access, ruined my career, whatever, no more career of this. Had I, when I did, in fact, reveal top secret information, had I committed a crime? They've never, under the Espionage Act, never considered that. They have not yet brought, however, district courts and appellate courts have upheld that, but it hasn't been tested in the Supreme Court. At my period, the best lawyers on this subject, like Melville Nimmer and some others, Benno Schmidt, have said, no, the law should have been held unconstitutional, even in my case, which would apply to all the other whistleblowers. That it was too great a restriction of freedom of speech to do that. But no district court has yet, or appellate court, has yet faced an indictment as that against Julian Assange of a journalist or a publisher. And remember, the case is being made whether he is a journalist or not, but that's pretty spurious. He serves the functions of the press that are protected here. They haven't brought that case before because every president has regarded that as too blatant a violation of the First Amendment, which protects freedom of the press. So they haven't even brought the case, unlike the very questionably constitutional cases brought against former officials or current officials. But against the journalists, they haven't tried. That's what's different under Trump. And the ACLU foresaw that Trump would be the person who would try to essentially abolish the First Amendment in the field of investigative reporting of so-called national security or military affairs or foreign policy of any kind. So the answer finally is to this, wrong answer, but yes, the wording is so broad, so clearly overbroad in this case that it could actually indict readers as well as secretaries or anybody who had unauthorized access to this, giving it to someone else who had unauthorized access, or even, in the wording of the law, failing to give it to someone who has authorized access, to return it to the government. So it's weird. Some of these professors, like Benno Schmidt knows, to say it's bad wording, bad drafting from any point of view. How could they have meant this? But there's no question, the words are there, and they are there to be found unconstitutional, I would say. So we have a peculiar situation here where Britain, is proposing to send someone, like an extraordinary rendition, practically, to another country to face a law that is manifestly unconstitutional applied to that person particularly. I don't, and there's one other aspect of this that needs mentioning. The Espionage Act is unsuited to be, from any First Amendment point of view, no, from any not First Amendment, just fair trial point of view, unsuited to test whistleblowers who are acting at risk, at the least, to their careers and their access, and we now know possibly of prison, in order to inform the public with a patriotic intention of preventing serious harm to other people, or past harm, or violations of the Constitution, as Ed Snowden revealed with the massive surveillance of all Americans, which is just recently, by the way, a district court has just found that blatantly illegal, which raises the question whether he should be charged at all. Okay. They can't, under the Espionage Act, which is called a strict liability act, in which motive and intention are not aspects of the crime, as they are in most criminal proceedings. The effect of that is, it just says, no, did you do what you're accused of? Did you give? Did you copy this stuff? Did you hold it? Did you retain it? These actions, we're not interested, and it's not relevant why you did it, whose lives you were trying to save by shortening a war or by ending torture, whatever, irrelevant. That's what I found in my own trial, and it's been true ever since. As I've often mentioned, in my own trial, I was asked on the stand by my lawyers, why did you copy the Pentagon Papers? And I'd been waiting to tell that in some detail under oath for 2 years. I'd held a lot back because I wanted to put it out under oath for greater credibility and authority. Objection by the prosecutor, the equivalent here of Lewis, QC, that's irrelevant. Seemed very strange, irrelevant. When I first heard that, I wasn't prepared for this. And my lawyer tried to put the question in. He says, motive, irrelevant. He reworded it several times to try to get it through. There are those who say it, had he been more experienced in criminal law instead of appellate law, he might have found a way. But objection upheld by the judge in each case. So finally, my lawyer, Leonard Boudin, in great frustration said, "Your Honor, I've never heard of a criminal case in which the defendant was not allowed to tell the jury why they did what they did." And the judge said, "Well, you're hearing one now." And that's been true of every whistleblower since. Tom Drake, Chelsea Manning, many others. So that's not a fair trial of a whistleblower. You can't have a fair trial of a whistleblower, or let alone a journalist, which is blatantly unconstitutional, as I said, but of anybody who violates a regulation, a promise they've made, not knowing what it would entail when they made the promise, that it would entail concealing crimes, lies, aggression, various things. When you enter government service, I think most people don't have a real sense that they may be getting into this, that they're joining a kind of mafia in many ways. People, I think, know what they're getting into with the mafia pretty much when they make a threat, when they make an oath of secrecy, which is the basic oath that you take when you become a made man in the mafia, an oath of omerta, of secrecy under any circumstances. When you go into the government, you don't think that they act like a mafia, as they do so often, sometimes in collaboration with the official mafia from Sicily when it comes to assassinations and dope dealing and various things. So you don't know when you say, "No, I won't tell any secrets that I'm supposed to do." You really generally at the beginning have little sense of what these secrets are. And the reason you don't, by the way, is that you're an American citizen who hasn't heard, because the secrets have been too well kept by too many people. So you don't know exactly what secrets you'll be asked to keep. And in any case, you're not able to testify on this. That means that Britain is proposing in this trial to send somebody to another country, to America, where they can't get a fair trial under the rules of that country, our country, which happens to have a First Amendment. Britain doesn't have that. So you can understand they're not being too concerned about that. In other words, you're sending it to somebody where the law they will be charged with is unconstitutional, applied to them. But you're also sending it to a country that doesn't have a public interest defense, a necessity defense, and a basis for explaining, as nearly all criminal trials do in anything that has something that can be, any country that can be said to have a rule of law or an independent judiciary. It's extremely unfair by any standards. And this is apart from the First Amendment. So the irony is that in Britain, there was a period when they had an explicit for public interest defense. And there was a period before that when they didn't. But then they passed that. So you could argue to the jury why you did what you did. And the result of that was in the Clive Ponting case, that when he revealed something that the public clearly, and especially the Parliament, had a right to know, and it had been concealed from them, and they had been lied to about it, namely that the Argentine battleship General Belgrano had been moving away from British ships. At the time it was sunk in the Falklands War, the Malvinas, rather than, as the government had sworn and had said, the Thatcher government, it was moving toward them and threatening them, and they had to sink it. Well, when that lie was revealed by Ponting, nevertheless, it was a secret. And I think he revealed it to a member of Parliament, as a matter of fact. And the judge virtually gave a directed verdict to the jury. He's done this. He's guilty. And the jury acquitted him. Well, they didn't like, as they had a right to do, and was right to do under the public interest defense. So they changed the law and they took out the public interest defense. That would mean it's like the US, where there isn't this, where we don't have that protection in the Espionage Act. Okay, I am told now, I understand, that Britain, however, is subject to the European Convention on Human Rights. which does demand a necessity defense or equivalent of a public interest defense. So he could get that. Julian Assange could have that in Britain, or Ike had it, not in the United States. So because the United States does not subject to the European Convention on Human Rights and doesn't allow it. So as I understand it, Britain is proposing to extradite somebody to a trial where he cannot get the protections he would have in Britain. And if I'm right on this, that seems to me essentially conclusive. But I don't know whether the defense is making that point as strongly as they could or not. But I did discuss it with the defense lawyer from my point of view, my experience, and I've just given you what my understanding is.
Yeah, so I'd like to wrap up our interview, but I'll give you an opportunity for any final words you might have. And I've got two ideas I just want to put to you, and maybe you have something to say about either of these things. First off, it's clear that the prosecutors are very frustrated that the Obama Justice Department did not indict Julian Assange after they prosecuted Chelsea Manning. They're upset that they can't show a very clear history, a very clear record of going after Julian Assange. And they're very frustrated that there are articles in 2013 that indicate that the Justice Department backed away from prosecuting Julian Assange. So I'm wondering if you have any thoughts as we end here about the political choice that the Trump Justice Department has made to pursue the case. And then I also note that the defense is doing something that they won't be able to do in a trial in a U.S. courtroom, which is that they're talking about U.S. torture and war crimes. We have Khalid al-Masri, who was the target and the survivor of CIA rendition and torture, who has submitted testimony in support of Julian Assange. But I just don't think the public in the US is going to see this kind of evidence, wouldn't hear from Khalid al-Masri. There will be no opportunity, as you say, with the public interest defense being prohibited, to put this into a case with Julian Assange. Your final thoughts?
Well, that follows from what I was saying earlier about the public interest, the lack of it in the U.S. I think you're absolutely right that the defense would not be able to put in the substance of what was revealed through Julian Assange as a publisher, as in the Chelsea Manning case. You would know better than I, Kevin, because you were able to follow the Chelsea Manning case. I was expelled twice from the courtroom for various other reasons when I was in the courtroom there. But I followed your reporting at the time, and was she able to bring in the substance material about torture and assassination into her trial? I mean,
yeah, because she pled guilty. There was this one day. We have one single day in the course of her court-martial in February of 2013. This was before the trial, where she made a statement to the court, and she read in some detail why she made the choices for everything. That's one of the only times that they were able to get it on the record, anything related to torture and war crimes.
That was associated with her pleading guilty?
Yeah, she was able to do it. She did.
That's wonderful.
The defense came up with a kind of workaround that if she pled guilty to lesser included offenses, she could give a public interest defense.
Terrific. Okay, well, I didn't get that in my trial. I wasn't pleading guilty to anything. And but there is an interesting aspect to that, by the way. And you asked me what else I'd like to bring in, and I will. But I want to agree with you that Julian would not get this, which is absurd, you see, in in the court in the U.S. And since the public here isn't reading transcripts or except for following your material, not in the mainstream press of it now, they won't know it. They won't know what it was 10 years ago. So no, he couldn't, and I couldn't argue at all of what it was I was revealing. Only address questions, whether the stuff they chose to charge me with, whether it hurt the national security or not, to have that out. And they chose not to charge me with things that made them look bad on their face, definitely. So much so that reporters covering the trial often, what is this trial about exactly? Because they weren't hearing anything that was very important to put out. The prosecution was just choosing elements that didn't look that important on the whole, but they were classified. That's all. And there were 7,000 pages there. We would have chosen other charges, let's say, to talk about that would have made people's hair stand up a little bit when they heard them. Okay. Now the other point here, though, when I say I'm reliving the trial, was listening to you just today and yesterday when I heard your reports, and Joe Loria's about these issues that are being raised. Actually, it's even more from a little bit earlier, when the question of jurisdiction came out, whether you could get a fair trial in the Eastern District of Virginia, okay, the hanging trial for whistleblowers, or people accused of leaks or something. I think none have ever been acquitted. And the reason being that, 60% of the people or something in that area are employed by some government agency, most of which have security clearances, NSA, DOD, DIA, FBI, maybe, all these things. They have security clearances and they don't acquit, let's say. Well, that took me back to my trial very much for much the same reason in a way. I had, in effect, two trials because they were interrupted by the revelation of a government wiretap of one of my lawyers. But after a jury had actually been selected, we were ready to go, and that was truncated. It turns out later, we found, they revealed that, somewhat to our surprise, that they had overheard somebody, because Kissinger and Nixon were on the tape. We don't want the trial before the election. Before the election, we're hearing that now in various cases. I think Eric Trump is raising that. Shouldn't be raising it before the trial. So before the election. Okay. The first jury, I was sitting there at the defense table, and my lawyers were doing a voir dire, questioning of prospective jurors. And of course, there's 11 people on the jury, as it was, but they would put a panel up of about 16 to be questioned at the same time, see if anybody's removed. And you could remove some people for just, I forget the word, well, some could be excused for cause because they were prejudiced, or couldn't admitted they could not judge fairly for one reason or another. And others were peremptory. That was the word. We could just get rid of them. But we only had a limited number of those, the peremptory challenges. Any number could be excused for cause, if there was a cause, or by the judge, by the prosecutor. Okay, so at one point, I asked my lawyers to ask the question at the beginning, have any of you possessed or currently have a security clearance? And so they asked the question. I'm sitting there, 16 people, and 13 raised their hands. I thought, what is this? For one time, I expected at that point I was going to go to prison for life. I didn't know the law. I didn't know the background. I didn't know no one had ever been prosecuted before. We just learned that, actually, but why they hadn't been prosecuted and so forth. So I expected to go to prison. And so I was living with that. But when I heard this, I had an unusual feeling for me, and the feeling was, okay, was fear. And it was not fear of going to prison because I expected that anyway. It was fear that this whole thing was going to be a charade, that it was going to be a mockery, that we were going to go through all these motions of a trial in front of a jury that could not possibly acquit me for two reasons. One, they had been told in order to get their jobs and in order to keep their jobs, and they believed it, that leaking any secrets would damage national security. Now, once you've been in the system for a long time, you know that's not actually true. Most of it would not damage national security. But when you first come into it, especially at the contractor level, which all these people were at Lockheed and North American and all these things, why did 13 out of 16 have clearances, for heaven's sake? Because they were being drawn from Orange County, which is a district of the military-industrial complex. It's almost the capital of it. And they were all engaged by defense industry. So they had been told that what I had admitted doing was putting out classified information was dangerous to national security.
Mm-hmm.
And second, they'd been told they would be prosecuted. It was criminal. They hadn't been told no one has ever been prosecuted under this because of the First Amendment. So it's a criminal event. It's very dangerous to the public. And third, they would be in danger of losing their clearance if I were acquitted. The question would arise, how had they voted? They'd be in a jury that acquitted me. Hard to have a clearance, especially a high clearance, if that had been the case. So they would lose their jobs. They'd have to move out of Orange County, which wouldn't seem to be the worst fate in the world, but they had children there in school and so forth. So they couldn't acquit me. And so we wanted the judge to excuse these people for cause. He wouldn't do it. We raised the motion. No, that's not a cause. The fact that they have, and this was so urgent to me. And I'm saying Julian is facing the same thing when it comes to Eastern District of Alexandria, of Virginia. As a matter of fact, his lawyers would, I would hope, raise the question, do you have a clearance? A lot, or have had one. A lot of them would say yes. And even if they no longer had it, they would want to keep their career opportunity open for getting it again, and in the government or in a contractor. So the judge would say, no, not for cause, as in my case. I was so concerned about this. I wrote a long affidavit, and I won't go through all that, of all the reasons why this was impossible for me to face. And he didn't seem to be responding to that. There was still a particular juror up there who was on this. And I was going to violate the regulations and stand up. I was absolutely ready to do it if they accepted this juror who had a current security clearance. And I was going to get up and say to the judge, Matthew Byrne, Your Honor, I cannot be fairly tried by a juror with a security clearance. And I had those words in my mind. I was going to do it. And I don't know if he saw that in me. I had put in the affidavit or something. I was just poised to get up and do that and be ruled in contempt or being ruled out of order like Julian when he hasn't been able to resist getting up at some point. The judge threatens him. Now, if that happened with a jury in the room, there might have been a mistrial. So I was ready to do that. And on that particular person, the judge excused that juror, and I didn't have to do it. But that's exactly, last point. When jurors are excused for cause or peremptory, the lawyers can talk to them afterwards. So my lawyers went to several of the jurors who had been excused who had admitted they had security clearances. And they said, among other things, and they said, how could you have said, as they had, they could try this case impartially, just on the facts, on what came out in the court and what they heard, if you feared losing your job, if you acquitted. And they all said, there were 3 or 4 of these, and they all said, well, he pled guilty. Well, I had not pled guilty. I'd pled innocent. We were putting the burden of proof on the government here. And we plan to argue, of course, the constitutional aspects eventually, which were very strong. And it's a good case on that in those days. The Supreme Court has changed now, so not so much now. So they each said, well, but he admitted what he'd done. And they had been indoctrinated that what I had done was a crime. That I was admitting a crime when I said that. As I say, no one had ever been prosecuted for it before. So that was what I was facing. Well, that's what Julian would be facing, and that's what others in the Eastern District have all faced. Britain is not sending them over to be justly tried, period. And we haven't even gone into the question of torture, but that's a whole other subject.
Yeah.
Clearly, he is, in the opinion of the UN rapporteur on torture and inhumane practices, Nils Melzer, and I believe another one who's gotten involved in this, yes, the isolation he's gone into and the treatment he's had in general amount to torture, or at the very least, inhumane and cruel treatment that should get him out of there. And that's a whole other subject. So I would say, this extradition thing in a truly just system here of law would be the idea of extraditing him for these offenses in the U.S. Should be open and shut. Should let him out. But as you know, that's not what's happening.
All right, Dan, it was great to talk to you. Thank you for taking the time to let me speak with you about what's been unfolding in the Assange trial.
Thanks for the opportunity, as they say. And thanks for what you're doing covering this trial at 3 a.m.
Well, it's an important case.
Right, it's worth it. It has no comparison to what Julian is going through. And of course, as Julian would say, no comparison to the torture and aggression and death, mass death, that he was trying to expose.